A pleasant afternoon to all of us. Welcome to another session in Organization and Management class. For today, I will share to you some case digests from court cases, which is between the employer versus employee and company versus client and vice versa. By the way, I am Clavel Joy Pinaso, welcoming you once again to another exciting session in Organization and Management class. So these are the following cases that I will be sharing to you. First, we have the Capital Wireless Incorporated versus Carlos Antonio Balagot. Second, we have the YHT Realty Corporation and others versus Court of Appeals. Third, we have the Hospital Management Services Incorporated, Medical Center Manila versus Hospital Management Services Incorporated, Medical Center Manila Employees Association, AFW, and Edna R. De Castro. Fourth, we have Ronda S. Vivares and spouses Margarita and David Suzara versus St. Teresa's College, Mylene Reza T. Escudero, and Jane Does. Fifth, we have the LBC Express Visayas Incorporated versus Monica C. Palco. So, before we proceed with the case digest, let us know first what is a case digest. So, a case digest or a case brief is a written summary of the case. A case sometimes involves several issues. So, digesting the same would help the student in separating one issue from another and understanding how the court resolved the issues in the case. So, let us have the first case. We have the petitioner Capital Wireless Incorporated versus Carlo Antonio Balagot under the GR number 169016, decided on January 31, 2007. So according to the labor code, double job per se is not illegal. So these are the facts of the case. Petitioner Capital Wireless Incorporated, or Capwire, hired respondent Carlos Antonio Balagot as collector on September 16, 1987. Carlos is required to work outside the office, and Capwire assigned to him a motorcycle as a service vehicle, for which it shouldered expenses for gasoline and maintenance. Balagot was discovered to have been rendering services to China Bank, and that since 1992. Carlos had been concurrently employed with Contractual Concepts Incorporated, a local manpower company which assigned him to render messengerial services to China Bank in the same year. Capwire terminated his services on the ground of grave misconduct and willful breach of trust and confidence. Capwire contends that the time of work of Balagot to other companies overlaps with his work at Capwire. Balagot admitted the charge, but he filed a complaint for illegal dismissal against Capwire and its president, Epifanio Marquez. So, the issue was whether or not Balagot was illegally dismissed. So, this is the ruling of the court. Verily, jurisprudence recognizes a valid ground for dismissal of an employee's unauthorized use of a company time. And from the evidence presented, Balagot used the company vehicle in pursuing his own interests on company time and deviating from his authorized route without permission. Capwire has all the right and reason to cry foul, as this is a clear case of moonlighting and using the company's time, money, and equipment to render service to another company. The court said that there is no denying that taking on double job per se is not illegal, according to the labor code, as extra income would go a long way for an ordinary worker like Balagot. The only limitation is where one job overlaps with the other in terms of time and or poses a clear case of conflict of interest as to the nature of business of complainants to employers. The contention of Palagot that he is working for China Bank after 5 p.m. is untenable because he was cited by the HR director within the premises of the bank at 3:35 p.m. and as general knowledge, the banking industry follows the ordinary working hours from 8 a.m. to 5 p.m., and a bank has no use for an employee who can only be of service to it after 5 p.m. Next, we have the YHD Realty Corporation and others versus Court of Appeals under the GR number 126780, decided on February 17, 2005. So these are the facts of the case. Maurice McLaughlin is an Australian national who comes to the Philippines for business. During his trips, he stays in Tropicana, a hotel recommended to him by Brunhilde Tan. So McLaughlin decided to deposit a cash and jewelry to the safety box of the hotel. The safety deposit box cannot be opened unless the key of the guest and that of the management are present. Lainez and Payam are employees of Tropicana who is charged with the custody of the keys. Thereafter, McLaughlin found out that some of the money and jewelry he deposited were missing. Lainez and Payam admitted that they assisted Tan to open his deposit box. Tan admitted that she stole McLaughlin's keys. Tan executed a promissory note to cover the amount of the stolen money and jewelry. McLaughlin wanted to make the management liable. So the issue of the case was whether or not a hotel may evade liability for the loss of items left with it for safekeeping by its guests by having the guest execute written waivers, holding the establishment or its employees free from blame for such loss in light of Article 2003 of the Civil Code, which avoid such waivers. So, this is the ruling of the court. The petition is devoid of merit. So, this only proves that Tropicana had prior knowledge that a person aside from the registered guest had access to the safety deposit box. Yet, the management failed to notify McLaughlin of the incident and waited for him to discover the taking before it disclosed the matter to him. Therefore, Tropicana should be held responsible for the damage suffered by McLaughlin by reason of the negligence of its employees. Under Article 1170 of the New Civil Code, those who, in the performance of their obligations, are guilty of negligence are liable for damages. As to who shall bear the burden of paying damages, Article 2180, Paragraph 4 of the same code provides that owners and managers of an establishment or enterprise are likewise responsible for damages caused by their employees in the service of the branches in which the latter are employed or on the occasion of their functions. The issue of whether the undertaking for the use of safety deposit box executed by McLaughlin is tainted with nullity presents a legal question appropriate for resolution in this petition. Notably, both the trial court and the appellate court found the same to be null and void. We find no reason to reverse their common conclusion. Article 2003 is controlling, thus Article 2003. The hotel keeper cannot free himself from responsibility by posting notices to the effect that he is not liable for the articles brought by the guest, and a stipulation between the hotel keeper and the guest whereby the responsibility of the former is set forth in Articles 1998 to 2001 is suppressed or diminished shall be void. Article 2003 was incorporated in the new Civil Code as an expression of public policy precisely to apply to situations such as that presented in this case. The hotel business, like the common carrier's business, is imbued with public interest. Catering to the public, hotel keepers are bound to provide not only lodging for hotel guests and security to their persons and belongings. The twin duty constitutes the essence of the business. So the law in turn does not allow such duty to the public to be negated or diluted by any contrary stipulation in so-called undertakings that ordinarily appear in prepared forms imposed by hotel keepers and guests for their signature. Next, we have the Hospital Management Services Incorporated Medical Center Manila versus Hospital Management Services Incorporated Medical Center Manila Employees Association, AFW, and Edna R. De Castro, under the GR number 176287, decided on January 31, 2011. So these are the facts of the case. Respondent De Castro was a staff nurse at Medical Center Manila. Calixi Han, HRD Officer of Medical Center Manila, issued a notice of termination upon Respondent De Castro for alleged first, negligence to follow company policy on what to do with patient Rufina Kosaren, who fell from a hospital bed. Second, failure to record and refer the incident to the physician on duty, allowing a significant lapse of time before reporting the incident. Third, deliberately instructing the staff to follow her version of the incident in order to cover up the lapse. And fourth, negligence and carelessness in carrying out her duty as staff nurse on duty when the incident happened. Respondent De Castro, with the assistance of Medical Center Manila Employees Association AFW, filed a complaint for illegal dismissal against petitioners with prayer for reinstatement and payment of full back wages without loss of seniority rights, 20,000 moral damages, 10,000 uh, exemplary damages, and 10% of the total monetary award as attorney's fees. So the labor arbiter ruled in favor of Respondent De Castro, stating that although De Castro committed the act complained of, being her first offense, the penalty to be meted should not be dismissal from service, but merely 7 to 14 days suspension, as the same was classified as a less serious offense under the Employees Handbook. The NLRC reversed the decision of the labor arbiter, stating that Respondent De Castro lacked diligence and prudence in carrying out her duty when, instead of personally checking on the condition of patient Kosaren after she fell from the bed, she merely sent ward clerk Oriente Galergan to do the same in her behalf and for influencing her staff to conceal the incident. The Court of Appeal reversed the NLRC's ruling and reinstated the labor arbiter's ruling. So the issue was whether Court of Appeals erred in affirming the illegal dismissal of Respondent De Castro. So the ruling of the court was the petition is unmeritorious. Article 282 of the Labor Code provides that an employer may terminate an employment for gross and habitual neglect by the employee of his duties. The Court of Appeals ruled that per the Employee's Handbook of Petitioner Hospital, Respondent De Castro's infraction is classified as a less serious offense for commission of negligent acts during working time, as set forth in subparagraph 11, paragraph 3 of chapter 11 thereof. Petitioner's anchor Respondent De Castro's termination of employment on the ground of serious misconduct for failure to personally attend to patient Kosaren, who fell from the bed as she was trying to reach for the bedpan. Based on her evaluation of the situation, Respondent De Castro saw no necessity to record in the chart of patient Kosaren the fact that she fell from the bed, as the patient did not suffer any injury and her vital signs were normal. She surmised that the incident was not of a magnitude that would require medical intervention, as even the patient and her niece did not press charges against her by reason of the subject incident. Neglect of duty, to be a ground for dismissal, must be both gross and habitual. Gross negligence connotes want of care in the performance of one's duties. Habitual neglect implies repeated failure to perform one's duties for a period of time, depending upon the circumstances. A single or isolated act of negligence does not constitute a just cause for the dismissal of the employee. So, negligence is defined as the failure to exercise the standard of care that a reasonable, prudent person would have exercised in a smaller situation. The court emphasizes that the nature of the business of a hospital requires a higher degree of caution and exacting standard of diligence in patient management and healthcare, as what is involved are lives of patients who seek urgent medical assistance. An act or omission that falls short of the required degree of care and diligence amounts to serious misconduct, which constitutes a sufficient ground for dismissal. However, in some cases, the court had ruled that sanctioning an erring employee with suspension would suffice, as the extreme penalty of dismissal would be too harsh. Considering that this was the first offense of the respondent de Castro in her 9 years of employment with Petitioner Hospital as a staff nurse without any previous derogatory record, and further, as her lapse was not characterized by any wrongful motive or deceitful conduct, the court deems it appropriate that instead of the harsh penalty of dismissal, she would be suspended for a period of 6 months without pay, inclusive of the suspension for a period of 14 days, which she had already served. Thereafter, petitioner hospital should reinstate respondent Edna R. De Castro to her former position without loss of seniority rights, full back wages, inclusive allowances, and other benefits, or their monetary equivalent computed from the expiration of her suspension of 6 months up to the time of actual reinstatement. So the petition of the hospital is denied. Every parent's dream is to see their child receive their hard earned diploma. But what do you think would they do if they found out that their child was not allowed to graduate? This case stemmed from the students of St. Teresa's College who were not allowed to participate in the graduation exercise due to their provocative posts in Facebook. The parents of the students filed a case against the school over invasion of privacy, where the girls' privacy actually violated. So this is a case between Ronda Ave S. Vivares and spouses Margarita and David Cesaro versus St. Teresa's College, Mylene Reza T. Escudero and John Does under the GR number 202666, decided on September 29 of 2014. So these are the facts of the case. Julia and Julian, both minors, were graduating high school students at St. Teresa's College, Cebu City. Sometime in January 2012, while changing into their swimsuits for a beach party they were about to attend, Julia and Julian, along with the several others, took digital pictures of themselves clad only in their undergarments. These pictures were then uploaded by Angela on her Facebook profile. At STC, Mylene Escudero, a computer teacher of STC's high school department, learned from her students that some seniors at STC posted pictures online depicting themselves from the waist up, dressed only in brasiers. Escudero then asked her students if they knew who the girls in the pictures are. In turn, they readily identified Julia and Julian among others. Using STC's computers, Escudero students logged in to their respective personal Facebook accounts and showed her photos of the identified students, which include Julia and Julian drinking hard liquor and smoking cigarettes inside a bar, and Julia and Julian along the streets of Cebu wearing articles of clothing that show virtually the entirety of their black brasiers. Also, Escudero students claim that there were times when access to or availability of the identified students' photos was not confined to the girl's Facebook friends, but were, in fact, viewable by any Facebook user. Investigation ensued. Then, Julian, and other students involved were barred from joining the commencement exercises. Petitioners, who are the respective parents of the minors, filed a petition for the issuance of a writ of habeas data. RTC dismissed the petition for habeas data on the following grounds. First, petitioners failed to prove the existence of an actual or threatened violation of the minor's right to privacy, one of the preconditions for the issuance of the writ of habeas data. So the photos, having been uploaded on Facebook without restrictions as to who may view them, lost their privacy in some way. And third, STC gathered the photos or the photographs through legal means and for a legal purpose. That is, the implementation of the school's policies and rules on discipline. So the issue was whether or not there was indeed an actual or threatened violation of the right to privacy in the life, liberty, or security of the minors involved in the case. So the ruling of the court was none. The Supreme Court held that STC did not violate petitioner's daughter's right to privacy as the subject digital photos were viewable either by the minor's Facebook friends or by the public at large. Without any evidence to corroborate the minor's statement that the images were visible only to the five of them, and without their challenging Escudero's claim that the other students were able to view the photos, their statements are, at best, self-serving, thus deserving scant consideration. It is well to note that not one of petitioners disputed Escudero's sworn account that her students, who are the minor's Facebook friends, showed her the photos using their own Facebook accounts. This only goes to show that no special means to be able to view the allegedly private posts were ever resorted to by Escudero students, and that it is reasonable to assume, therefore, that the photos were in reality viewable either by their Facebook friends or by the public at large. Considering that the default setting for Facebook posts is public, it can be surmised that the photographs in question were viewable to everyone on Facebook, absent any proof that petitioners' children positively limited the disclosure of the photograph. If such were the case, they cannot invoke the protection attached to the right to informational privacy. Lastly, we have the LBC Express Visayas Incorporated versus Monica C. Palco under the GR number 217101 decided on February 12 of 2020. So I specially included this court case as we are observing the 18-day campaign for the violence against women and children. This is about sexual harassment in the workplace and the action of the office towards the complaint of Miss Monica Cipalco. An employee is considered constructively dismissed if he or she was sexually harassed by her superior and her employer failed to act on his or her complaint with prompt and sensitivity. In the above cited case, what started to be near flirting coming from an immediate supervisor escalated into a full-blown sexual harassment. The victim employee filed a complaint with the head office of the employer, but this was not acted upon promptly. These are the facts of the case. Respondent Monica C. Palco filed a complaint for sexual harassment before the Danao City Prosecutor's Office, alleging that she was harassed by her supervisor, Arturo Batucan, and that her employer, petitioner, LBC Express Visayas, failed to take immediate action on the matter. The labor arbiter, ruled in favor of Palco. The National Labor Relations Commission and the Court of Appeals likewise ruled in favor of the respondent. In view thereof, LBC filed this petition, arguing that they should not be liable for constructive dismissal and that it cannot be held liable for the sexual acts of Batukan. So the issue was whether or not sexual harassment done to Monica Palco constitutes to her constructive dismissal. So the ruling of the court was yes, the sexual harassment done to Palco can be a compelling reason for her to complain against constructive dismissal. Constructive dismissal occurs when an employer makes an employee's continued employment impossible, unreasonable, or unlikely, or has made an employee's working conditions or environment harsh, hostile, and unfavorable, such that the employee feels obliged to resign from his or her employment. One of the ways by which hostile or offensive work environment is created is through the sexual harassment of an employee. Palco posited in this case that her resignation was not voluntarily but was born out of the hostile work environment brought about by Batukan's sexual harassment. Thus, this petition was denied by the Supreme Court. And so, that would be all. I hope that you have learned something from the case digest that I have shared to you. Once again, thank you so much and thank you for joining today's class. Bye bye.